And actually, first on the agenda is Senator Gardenhire on Senate Bill 612. You're recognized, Senator, and I believe we have a motion and a second, and we have an amendment. Has that been moved and seconded? And that has not been acted on, or no motion on it. Yes, sir. You're recognized.
Thank you, Mr. Chairman. I think the only question left was somebody wanted to speak from the Attorney General's office, and Bill Young from the office is here to. The question I think Leader Norris had was this amendment pass muster?
Senator Norris,
thank you.
Wish us to stand in recess?
Yes, Mr. Chairman, if we could. The amendment, I think the amendment that had come to us now deals with those lawfully present, and I guess you've had an opportunity to look it over, but I still sense that your office had concerns given the litigation we're in, and if you could address that.
Without objection, we're in recess, and this is discussion on Senate Amendment 5763. General?
Thank you, Chairman McNally. Again, for the record, Bill Young, Associate Attorney General with the Tennessee Attorney General's Office. Leader Norris, in response to your question, our testimony last time was that the bill as drafted we thought was legally defensible. With this change, where we're talking about someone who's lawfully present, we certainly would think it's legally defensible. As I stated last time, we don't want to get too much into the weeds on this given the litigation that we're involved in Texas. But the lawfully present language really takes it out of dealing with someone who's unlawful. As the bill is amended now, will require that they have to be lawfully present in order to qualify for this benefit.
Leader Norris?
Thank you, Mr. Chairman. I agree. I think it makes it a better bill in the sense that it narrows the scope. Over the weekend, I've read there's a back and forth about whether DACA is implicated or not, and the sponsor has, and I think correctly, tried to state that it's not, but there are those who think that it is, and that's a patch of weeds that I'm sensitive to given the litigation. And would you agree that it is a good idea to continue to be sensitive to that, regardless of the?
Oh, absolutely, Leader Norris. I would be sensitive to it. I agree with you.
Okay, thank you.
Further questions? Yes. You recognize Senator Hensley.
Thank you, Mr. Chairman. So this makes it, I'm still not clear about who is here lawfully present. The students that have been brought to this country illegally and are here illegally are not here lawfully. So what? Maybe you could clear up to me who this would include by us putting this in here that are here lawfully but are not citizens of this country.
And Senator Hensley, I would defer to the sponsor of the bill on this, but my understanding is to the extent that the United States Department of Immigration would consider someone here, quote unquote, lawfully present, then this bill would apply to them. That's my understanding. So they would have to be considered to be in this country and lawfully present under the standards established by the United States Immigration Department.
But someone,
Homeland Security in this case.
Someone brought here, say someone brought here when they're 10 years old by their parents. The parents are here illegally. They're here illegally. They're going to still be here illegally, right?
If they're here illegally, I don't see how this bill could apply to them. They would have to be here lawfully present by the terms of the amendment to the bill, as I understand it.
And one other part of this bill says they graduated from a Tennessee high school or obtained a GED by a state-approved institution or completed high school in a homeschool program. Getting that GED, that student wouldn't have to go to a Tennessee high school, would they? If they just came to this state and got a GED here, would that student still have to go to a Tennessee high school?
Senator Hensley, you're getting me into the weeds. Off the top of my head, I would say you could get that GED without attending the Tennessee high school. That's how I believe it works.
So
With asking me off
Right.
the top of my head, and either one of the three criteria, as I read the bill, you have to meet one of the three.
So, with that criteria in here, a student wouldn't even have to go to a Tennessee high school. They could move here from some other state, get a GED here, and then get in-state tuition here.
I would defer to the sponsor on the intent of his amendment and his bill, but as
Okay.
I read it, it would be one of those three, correct?
Okay, thank you.
Further questions? Yes, Senator Ketron and then Senator Stevens. Chairman Ketron?
Thank you, Mr. Chairman. General Young, I was doing some research back in 2011. The governor in Maryland had worked on a bill. It was Senate Bill 167. And they had something very similar. It was a way for Maryland to try to get around the federal law that was passed in '96. And it talked about the bill exempts individuals, including undocumented immigrants, from paying out-of-state tuition if the person attended a secondary school in the state for at least 3 years, graduated and received a GED in the state, and proves that his parents have filed Maryland income tax returns annually for a 3-year period, and the student attended school in Maryland, and the states that they will file an application to become a permanent resident. So, kind of taking on what this amendment is, could we require, if we're looking for lawfully present, could we require documentation showing that?
Senator Ketron, I see no reason why you couldn't. And in fact, I assume that in order to get the benefit, that you would have to show some evidence that you're lawfully present. Now, what that evidence would be, I don't know, but I would assume in order to get the benefits, you would have to document that term, that requirement, as well as one of the other three requirements.
I'm thinking we might need to put that in writing. You know,
And I'm at, for policy reasons, I'm at the discretion
Sure.
of this committee as well as the sponsor of the bill.
I'm still struggling with the fact that the bill that Bill Clinton signed in 1996 on the Immigration Reform Act still says that federal law and Congress, I think, sent a strong message that that no student would be able to get that tuition unless all students. So we just get rid of all in-state tuition or out-of-state tuition and let all students come regardless. And maybe I think that was a clear message that Congress sent to us. But states are trying to avoid that. Mr. Chairman, I would like to amend the bill to at least
Chairman, we've not adopted the amendment, so
Okay.
after we adopt the amendment, you can try to amend it.
Okay, I'll come back on that. Excuse me. All right, I'm through with my questioning for the general.
Okay. And Senator Stevens, and then I have Chairman Overby.
Thank you, Mr. Chairman, and you actually hinted my question. You hinted a response to my question, but I want to emphasize it. And if you don't know, just you'll let us know, and I'd like to hear the answer to this. But since we're requiring them to be lawfully present, what would they present to the school demonstrating they're lawfully present? What documentation is there? Is there something that exists that they could present to the school with their application?
And again, Senator Stevens, Senator Ketron animated, maybe you want to put an amendment on there to require it specifically, but I assume it would be a birth certificate, a social security number, other documentation indicating that you are lawfully present in this country, and it would be up to the receiver of that information to determine whether or not the criteria was met.
What's her name?
So those are the only forms of identification that you're aware of that would demonstrate lawfully present?
And Senator Stevens, I'm talking off
Okay.
the top of my head.
Okay.
There may be other documentation that would be just as convincing, but generally when someone asks me that question, that's usually what they want to see.
Thank you. Mr. Chairman, I would like, if at some point, if there is somebody in the audience who perhaps can answer the question of what documentation is available that would demonstrate that that someone is lawfully present.
Senator Gardenhire, you have a witness that could join us.
Yes, Mr. Chairman, thank you. Young lady, step up to the microphone and introduce yourself.
My name is
you
Stephanie
heard,
Tetro with the Tennessee Immigrant and Refugee Rights Coalition.
I think you heard Senator Stevens' question, if you could.
That's right. So for students who are approved for deferred action and are granted lawful presence, they receive a work authorization card, which TBR and the UT should be familiar with, as well as a social security number.
Senator Stevens?
Thank you, Mr. Chairman, and that's issued by the Department of Homeland Security.
That's right.
Okay.
And
Thank
so those two documents together are valid to receive a Tennessee driver's license as well as many Tennessee professional licenses. And so there's many other departments in place who verify these documents.
Thank you, Senator Stevens. And yes, Speaker Pro Tem?
I didn't mean to interrupt, but I just wanted to ask, and how long has that process been in place?
So the program or the idea of deferred action has been in place for decades. The program that affects these young students has been in place since 2012.
Chairman Overby.
Thank you, Mr. Chairman. Chairman Ketron's question, General Young, just raised the thought in my mind. Generally, is there a presumption that a person is in the United States lawfully until proven otherwise? Is there any sort of presumption that applies?
Senator Overby, I don't want to get in the weeds on immigration law. It's not my area of expertise. But for purposes of this bill, which is what you're talking about getting a benefit in state tuition, I would assume anyone who wants that benefit would have to show something to show that they meet the criteria, whether it's the lawful presence criteria or that they have graduated from Tennessee High School, got the GED, or graduate from homeschool. There would have to be some documentation in order to get the in-state tuition. I'm not assuming the state of Tennessee would just give that on request.
Gotcha.
If
Thank
I
you.
may also address Senator Ketron's question around the Maryland law and other similar laws, the way they are designed, it's in reference to U.S. Code 1623, which this committee has discussed before. But that part of the federal code is actually referring to people who are not lawfully present. And so the folks who are covered by Senator Gardenhire's amendment, U.S. Code 1623 does not apply to them at all.
Oh, thank you. Next, and I think this is the last question, Senator Hensley.
Thank you, Mr. Chairman. Do most high school students get a work permit?
As we discussed last week, the students who would qualify to apply for this work authorization and deferred action status have to meet some stringent criteria and individually apply. We do have a student here today who has received deferred action and who can testify to the process that she went to. But the students to qualify have to arrive in the U.S. before they are 16 years old, pass a criminal background check, meet certain educational requirements, must have been in the U.S. for at least 5 years, and have been continuously present since then. So no, not all high school students receive work permits. But it is the same work authorization that many students on different immigration status receive. It's a long-standing form of temporary immigration status.
And I don't want to put you on the spot, but are these students here with you here today legally?
Lawfully present.
Lawfully present? They are? Okay. Thank you.
Thank you. Senator Ketron.
Thank you, Mr. Chairman. Do these students that come, do they have the desire to become a permanent resident?
Yeah, so I think that for the students who qualify for this program, this is absolutely their only pathway to a status. And so we receive that question a lot, but the rates of application, once this pathway opened in 2012, it's already close to 8,000 students have applied in Tennessee, 7,000 have been approved, which is the vast majority of those who are currently eligible. So what that shows us is that as soon as there is a pathway available, these students will get in that line. And so because deferred action is not does not have all of the benefits and rights and responsibility of permanent residency or citizenship, all of our members are eager to apply for permanent residency when the opportunity is available.
So you wouldn't have a problem of putting language in there saying that before they could qualify for this, that would be one of the documents that they would have to show that they have applied with an application to become a permanent resident?
So the application is not available for these students. So that would make no one eligible for in-state tuition under this amendment. But in the previous bill and in what Maryland has in their amendment is the affidavit clause, which says that students could qualify if they sign an affidavit saying that as soon as an application is available, they commit to applying. But at this point, the students who have received deferred action cannot apply for permanent residency.
That's a federal mandate?
Yeah. There's you have to have a certain pathway to apply for a green card, which is permanent residency, and these students don't have it at this point.
So if they don't have a green card, how do they get a Social Security number?
Because they're considered lawfully present. And so green card is often the final step. In my family, I had a visa and a work permit and a Social Security number for close to 7 years before I was able to apply for permanent residency.
That makes sense.
It's a very complicated immigration system, but the sort of bottom line is for these students, an estimated 25,000 in Tennessee, they do not currently have the opportunity to apply for permanent residency or citizenship. In the meantime, they've been given a temporary status with work authorization, a Social Security number. They've registered with the federal government. They can work here, they can get professional licenses here, but at this point they cannot receive in-state tuition. So I would agree the system is broken and confusing, but this is the state that we're in now.
Thank you, Mr. Chairman.
Thank you, Senator Ketron. One question before you leave. Pass a background check. That means no felonies. And what about misdemeanors?
Yes. So I apologize, I don't have it right in front of me, but no felonies, no significant misdemeanors, and no more than 3 simple misdemeanors.
Okay. Thank you. Thank you. We appreciate your testimony. We're on the amendment, and this is Drafting Code 5763. And I'll ask for a motion on the amendment. Senator Overby moves the amendment, seconded by Senator Dickerson. Is there further discussion or questions of the senator on the amendment? Seeing none, all in favor of the amendment say aye. Aye. Opposed, nay. The amendment passes. On the bill and I believe Senator Ketron and Senator Stevens possibly have amendments, and if this is all right with both of you gentlemen, we would probably combine this with the original amendment, and that way just be dealing with one. You're good? Okay. Is there any further questions? Seeing none, the Secretary will call the roll, and this will be on Senate Bill 612 as amended.
Senator Dickerson votes aye. Senator Hill votes aye. Senator Harper votes aye. Senator Hensley votes no. Chairman Ketron votes no. Leader Norris pass. Vice Chairman Overby votes aye. Senator Stevens votes aye. Senator Tate votes aye. Vice Chairman Watson votes no. Chairman McNally
Aye.
votes aye. Mr. Chairman, we have 7 ayes, 3 noes, and 1 pass.
Thank you. The bill is referred to the Calendar Committee. Next.
Thank you, Mr. Chairman. Thank you, Committee.
Thank you. Next, we